So welcome to the audiences of Ambedkar Caravan. Today we have a very special uh, presentation by Dr. Nitish Nawsagare, who is an assistant professor in ILS Law College in Pune, and he is going to talk about the constitutional morality and majoritarian rule, and he is widely read person in the law, constitution. He teaches law and constitution in ILS, and also he is very much sought after speaker on these issues and also the social issues. He has been analyzing the social, economic, political situation of this country for a long time, and he is going to talk to about this very important topic to us today. Joining with us today is also Advocate Priyadashi Telang, and at the end of Dr. Nitish Nawsagare's presentation, we will invite some questions from the audiences, and also Priyadashi will take up those questions, and there will be question and answer sessions. So I request Dr. Nitish Nawsagare to present his ideas on this very vital topic. Sir.
Yeah. Thank you, Mangesh. Thank you for inviting me on Ambedkar Caravan. The topic for discussion today is constitutional morality, and I'll recoin it: constitutional morality and its relevance in a majoritarian democracy. Democracy, as has been defined, is always in a very traditional form to be a form of government, which is government of the people. It is also called as a government by discussion and deliberation. But for Dr. Ambedkar, democracy has a very different meaning. He says about it's a social and economic change. Democracy is a means by which we bring a social and economic change without a bloodshed. And therefore, democracy for Dr. Ambedkar was always a way of life, more than not only a political theory, or not only a political doctrine. Now, if we look at this part, therefore, what is constitutional morality and why we are looking at vis-a-vis a majoritarian democracy? Recently in India, there's a lot of interest in generated amongst academicians, lawyers, scholars, politicians to discuss and deliberate about constitutional morality. The first reference in India regarding a very intellectual deliberation on constitutional morality comes up in the writings of Dr. Ambedkar himself. He refers it in many of his writings, but the major take which has popularly been taken up is his speech in the Constituent Assembly on 4th of November 1948, when he has presented the draft constitution. At that time, there was a criticism against the draft constitution that it is too elaborate. Now, let us understand that by that time, the constitutions which we had as one of the model constitution was the American Constitution, which is quite small in nature. And the whole idea was that we should only speak about the principles and leave all other details for the parliament to work out with. On this backdrop, the Constitution of India was quite an elaborate document which was drafted. And therefore, the criticism which was there, that it is quite elaborate. You speak about whole administrative mechanism, you speak about whole detailing of the administration. Do we need it in the Constitution? To answer this, Dr. Ambedkar has justified why we need an elaborate, detailed Constitution. And while answering this, he says that, he invoked a historian, Greek historian, Growth, and he says that there is something called as constitutional morality. So what is constitutional morality? He says it is adherence to the principles of the Constitution, both by the majority and by the minority. And then he makes a comment and he says that, unfortunately, the constitutional morality is missing in India. To quote him verbatim, what he said about is that constitutional morality is not a natural sentiment. It has to be cultivated. We must realize that our people have yet to learn it. Our people, means Indian, have yet to learn it. Democracy in India is only a top dressing on an Indian soil, which is essentially undemocratic. So this is the point he wanted to make whole of his life when he spoke about Indian politics, when he spoke about India and its reference to democracy. He says democracy in India is a top dressing on an Indian soil. And how is the Indian soil? Which is essentially undemocratic. So this is how India is about, and therefore that is the reason we need a written law which is too elaborate, too detailed to tell you what to do and what not to do. It means that if at all the behavior of the Indians was more democratic in nature, essentially they were democratic in their behavior. If democracy would have been the way of life, then in that case, I would have not been compelled to draft a very detailed constitution for you. That is what he wanted to say. Dr. Ambedkar has made a reference to constitutional morality in few other parts earlier and after this. The first reference you can find in his writing on what Congress and Gandhi has done to untouchables. And he has been critical of the foreigners. He says that you feel that giving self-government is sufficient. But who is the self here? Okay. He says that whenever will you give democracy to India, at that time, the foreigners feel that we should give charge to the Indians. We should give charge to Indians, and they appreciate Gandhi and Congress, but they are not very much appreciating the other forces. And he says, who are these people who will be getting power after independence? And he says they are the people who are haves, and these people who are haves will control all the resources. So will it be an appropriate democracy? He says it will be only government not government of the people and by the people. Okay, so he's talking about whether actually people will get a representation. The same concern he keeps on raising in many of his writings. The major part we'll take up and then we'll come to what is happening today is that when Babasaheb Ambedkar gave a speech in Pune, prerequisite for functioning of a parliamentary democracy. So one of the prerequisites for the functioning of the parliamentary democracy says that we should also have constitutional morality. And what is constitutional morality? Wherein it says that a constitution is only a skeleton. Constitutional morality is basically flesh into it. It cannot be just only in written form. It is basically the ethos of the society. And then he keeps on coming up to this point that Indian society is very much undemocratic in nature. He also spoke about it in his last speech in the Constituent Assembly on 25th of November 1949, where he says that we will be entering into an age of contradiction where we will have political equality, but will not have social and economic equality. And then we have to bring this social and economic equality as early as possible. He also cautions that we should not keep our liberty at the feet of anyone, howsoever big he may be. And we should do away with those old weapons of satyagraha and non-cooperation when we have a constitutional methods. Now, taking this whole part, what is Dr. Ambedkar speaking about? He says that we should have an adherence to constitutional values. And adherence to constitutional value is very much missing in a society. Recently, Supreme Court, so he was projecting constitutional morality in two manners. In one manner, he was saying that constitutional morality basically could sustain only in a society which has democracy as a social value, not only as a political value. And then he was also saying that constitutional morality are the values on which all other moralities could be tested. He was also a person who says that it is basically not only substantive in nature, but also something which is beyond that. Let me put up this part in some details. Recently, Supreme Court has came up with few judgments wherein all of a sudden they have started invoking Dr. Ambedkar in interpreting the Constitution. It for the first time happened in the judgment of Nas Foundation of Delhi High Court, wherein the question was about the constitutionality of Section 377 of the Indian Constitution, that is, which criminalizes homosexuality. Now, the argument of the government was that why do we criminalize homosexuality? For the reason that it goes against the religious morality, it goes against the public morality. Therein, the court says that, but Article 21 of your Constitution gives you individual liberty, and therefore it says that which morality will prevail. If the Constitution gives you individual liberty, whether the morality of the Constitution will prevail or morality of the society will prevail. They said that the morality of the Constitution will prevail, and they invoke Dr. Ambedkar, that constitutional morality will prevail over public moralities. That takes to a very interesting debate. And this debate is that whether the Parliament of India, whether the lawmakers or people who make the law, okay, are the people who actually command a popular sovereignty. And if they say yes, should popular sovereignty will determine rights and liabilities of the people. And here in this case, we say that howsoever strong any lawmaking body would be, it is subject to a set of morality which is called as constitutional morality. Anything done on the whip of a popular sovereignty would not be correct. And therefore, Supreme Court has time and again said that the institution of Supreme Court is basically anti-majoritarian. It means that Parliament on the whip of the majority can make any law. But Supreme Court struck it down because they say that we are here to uphold the Constitution and not what the Parliament says. And this is what constitutional morality would be, that it would basically take you to a point that if the majority of the society decides in one way, but if it goes wrong, you can struck it down. How does Ambedkar decide Indian politics? He says that in communal deadlock and how to solve it. Dr. Ambedkar says that the majority in India is communal majority, right? It is not a political majority. What is the distinction between a communal majority and a political majority? A communal majority is born. So I am a Hindu and therefore I'll decide how a Hindu should decide. Okay. A political majority is created. It is made and unmade. So my ideologies will keep on changing. In India, the majority is communal majority. We are born with an ideas. We are born with an ideology. We don't change ideologies. And if that is the case, how would the minorities will feel secured in a society where the majority is a communal majority? In this context, the reference of constitutional morality becomes important. If you see the Constitution of India, if you see the chapter of fundamental rights, world over, fundamental rights are available against the state. The Constitution of India says that fundamental rights are available against fellow citizens. Read Article 17 says that it is available against fellow citizen for violation of untouchability. Article 23, forced labor, it is available against fellow citizen. So fundamental rights in India are not vertical, not only vertical in India, they are also horizontal. And that what makes the Constitution transformative in nature. So constitutional morality is a compass in a troubled time which will make you understand what should be done and what should not be done. Now let me come to some political discussions which has happened. On 5th of August 2019, the Parliament of India all of a sudden abrogated Article 370. We don't go into the detail of it. Sometime we may have a detailed discussion on 370 and its legality. But let us come to some point where the issue of constitutional morality could have arisen and should arise. Is that when the matter came before the Rajya Sabha on 5th of August 2019, at that time, the members of Rajya Sabha were not even informed that such type of resolution, such type of bill is about to come. There was a lockdown in Kashmir. The member of parliament from Kashmir were not allowed to come in the parliament. And then all of a sudden, on the basis of majority in the House, Article 370 was repealed. We'll look at the legality afterwards. The point is that whether it was justified in doing so. Are we correct in getting things done in such a manner? Is it moral to do so? And again, at this moment, I would like to invoke Dr. Ambedkar. And I'm invoking Dr. Ambedkar. It happened so that in the Constituent Assembly, when the objective resolution was tabled by Nehru on 13th of December 1946, at that time, Barrister Jaikar raised an objection saying that let Muslim League and the princely state also come in the Constituent Assembly. Then we'll start the discussion. And the House said that no, we should continue with the discussion. At this moment, Dr. Ambedkar rose and he spoke about, and what he spoke about is something which is very important. I'll quote him, and he says, it may be that you have a right to do so because you have a majority in the Constituent Assembly now, right? Congress was in majority. It may be that you have a right to do so. The question I'm asking is this: is it prudent for you to do so? Is it wise for you to do so? Power is one thing, wisdom is quite different thing. And I want this House to consider this matter from the point of view, not of whether authority is vested in this Constituent Assembly. I want this House to consider the matter from the another point of view, namely whether it would be wise, whether it would be statesmanlike, whether it would be prudent to do so at this stage. I think this is what Dr. Ambedkar was talking about. When the Constitution is silent, when the laws are silent, do you want to do so just because you have a right to do so? Or is it something like, is it wise to do so? Is it like statesmanship? So, abrogating of 370 without even consulting the members of Jammu and Kashmir, the governor giving a consent on behalf of a dissolved legislative assembly, where the governor happens to be a nominated authority of the president, and he gives consent on behalf of the state. whether it is, forget about the legality, whether it is wise to do so, whether it is statement like. And therefore the question comes about constitutional morality. The question is about constitutional morality. In Maharashtra, when Article 376 was imposed, and all of a sudden, Mr. Devendra Fadnavis and Ajit Pawar, they swear in as the chief minister and deputy chief minister early morning at 7 o'clock, and 376 was revoked back at midnight. Now the point is that whether technically can you have a swearing ceremony early in the morning? Yes, nobody stops you. The constitution is silent on this point. The point is whether the governor is justified in doing so, whether it's constitutionally moral to do so. And therefore, when the constitution is silent, it is the constitutional morality which will decide what to do and what not to do. So what is constitutional morality? It is basically something which all the people who are holding a constitutional position should adhere to. Where the constitution is silent, where the constitution gives discretion, this is something which governs, and it has to flow from the values of the constitution. And the values of the constitution are liberty, fraternity, and equality. So whether every authority should look into whether the way I'm behaving, whether it's arbitrary in nature. If it is arbitrary in nature, then definitely in that case, it is against the constitutional morality. One thing we have to keep in mind that we really forget that the model on which Dr. Ambedkar has designed the Indian Constitution is based on the British Constitution, which is based on the British conventions, which is very much unwritten. And therefore, he had in mind that a functioning of a parliamentary democracy is successful only when we also adhere to certain moral values which we stand upon for years together. And therefore, upholding those British conventions in the sense that conventional law is more important where this constitution is silent. So we don't have to go only for a written constitution. And therefore, I suppose that in this troubled time today, when we feel that what to do and what not to do, how to go ahead with, it is Dr. Ambedkar's doctrine of constitutional morality which will show us a path to again say that it is a compass in a troubled water. It will tell you the right direction, where to go and where not to go. I think I'll make a pause here, and if there are any questions, we'll take questions and then we can move further.
Dr. Nitish Nawsagare, that was a very succinct and very clear presentation on the constitutional morality. These days, there are a lot of questions about the majoritarian state and also the undermining of the democratic institutions. So when we look at this element and this principle of constitutional morality, it applies to the governments and the various organs of the governments. Also, how it relates to the public conscience. How does it needs to be inculcated in the minds of the citizens? What can be the various means or the ways by which the constitutional morality becomes a kind of a way of life for the people? And if and how will you explain the way of life as the constitutional morality, as the governing principle of our countries that is enshrined in the constitution, as you said, liberty, equality, and fraternity? Sir.
Well, I said adhering to constitutional modes and constitutional values means that is what Dr. Ambedkar was speaking about, that if you have a problem, you can't go by unconstitutional ways of solving it. You have to take recourse in the constitutional models and ways of solving it. This is the first part, and that has to be imbibed. Unfortunately, we are governed by the constitution, but we behave in the similar manner the way we used to behave earlier 1950. So that is the problem we have. We still feel that we have a constitution, but we can't take any recourse, any remedy into it. We don't make the people holding the constitutional authorities to be answerable. So the first part is that people holding the positions to be made answerable, and common man should always look into going for constitutional means of enforcing their rights and the grievance redressal. This is the first part you have to do. Second part is about constitution is not only about governance. Constitution is also about your way of life, how you want to have. And therefore, should we wait for the parliament to pass a law on abolition of untouchability and abolition of sati system and abolition of some other part? But the constitution, when it speaks about equality, should the people wait for parliament to make a law and then they should reform, or should reform come from the people? This all debate comes in. Now let us take the case of Sabrimala. In Sabrimala case, basically you have a tradition of long-standing years that women in the menstrual age will not be allowed to enter a temple. Now, if you speak about this morality, this is a morality of a majoritarian community, which is patriarchal in nature. This is a morality of the people which feels that the religion has sanctioned it. But what does the Constitution say? The Constitution says that there cannot be discrimination on the basis of gender, even at public places, right? Now, what is important is that should we uphold the constitutional morality? Now, it happens that we have a constitution at one hand and we have a religion and you have all other institutions on the other hand, which are completely opposite to the constitution functioning in society. Now, in such type of society, functioning of the constitution becomes impossible. If a political party says that mandir wahi banayenge, and if it is part of the manifesto of a political party, then in that case, are we in what framework of the constitution that you want to fit it? And then if that becomes a popular sovereign ideology in a sense, what we do is right, then in the constitutional structure, this so-called social democracy, these people keep on speaking that this is a Hindu Rashtra. Now, how it goes against the whole ideas, ethos of constitution. So you have Supreme Court judge who says that had it been a Hindu Rashtra, I would have made Bhagavad Gita to be compulsory. So in this manner, the people should keep on questioning that under what constitutional framework you could speak this, right? So if you want to make democracy to be a way of life, then in that case, it doesn't start with the parliament, it starts with the social movement. Okay, so Phule, Ayoto Das, Babasaheb Ambedkar, Periyar, these are the people who made democracy, social democracy meaningful. These are the people who spoke about caste discrimination. There's people who spoke against caste patriarchy, against exploitation, and social movements, so long they get strengthened, constitutional morality will automatically imbibe.
Sir, just one question before I hand it over to Priyadarshi. It's coming from the audiences. Ms. Disha Wadekar has a question for you, sir. The question is, how has constitutional morality been defined by Supreme Courts in recent years?
Okay. Supreme Court has defined constitutional morality in different manners. Means sometimes they say it is a conscience of, it is a conscience of the Constitution. And therefore, they say that you can read constitutional morality in the preamble, in the chapter of fundamental rights, and in the chapter of directive principle. It says that it is the soul of the Constitution. So basically, they're equating it with the basic structure doctrine, saying that it is something which cannot be compromised at any point of time. It is the soul of the Constitution, Justice Deepak Mishra's judgment. And something it says that whenever there is a tussle between the public morality and constitutional morality will prevail, because constitutional morality flows from the Constitution and not from the religion. So how they've defined, there is no one single definition, but what they try to mean is that they're equating constitutional morality with basic structure doctrine, that considering it that it is the soul of the Constitution, which is not to be compromised at any point of time. And Justice Chandrachud said that it is a compass in the troubled water. So we cannot, it is something which will guide us while interpreting the Constitution. Yeah.
So Advocate Priyadarshi Telang is here, and he would take this Q&A session. Priyadarshi sir, handing over to you.
Yeah, thank you, Mangesh. Thank you, Nitish sir, for beautiful presentation, taking us through the constitutional debates, assembly debates, to the interpretation of constitutional morality or application of constitutional morality in recent judgments. Sir, in your presentation, you certainly invoked the examples of the Jammu and Kashmir. You also suggested what happened in the formation of government in the Maharashtra. In this context, sir, there are no questions so far from the Facebook Live, but from your presentation, I would like some points for clarification and points to be taken. Sir, if you remember, in recent past, constitutional morality as a doctrine been applied by Supreme Court, and also is being invoked by the person who are in the constitutional force. Particularly, I would like to cite an example where President invoked that opposition parties should follow the principle of constitutional morality while commemorating Constitutional Day. And when we see the example, the same person, while the formation of government of Maharashtra, he didn't apply the same principle in the same way, right? The directions given to the governor or the directions cited by the governor are very different. So in this respect, how you see the application of it from the person who is holding constitutional post?
Yeah. See, it has recently been a fashion amongst top political leaders to invoke Dr. Ambedkar and quote him. And on 26th of November 2019, the President of India spoke about constitutional morality. That is what Dr. Ambedkar has said about this part. And he said that everybody should adhere to constitutional morality. And he was hinting it to the opposition. But the same person on the same time span during the same period has revoked back 356 in Maharashtra and allowed the government to swear in the BJP government early morning at 7 o'clock. Now the question is that if the governor does it, the governor is directly answerable to the president. So we have nothing on record which says the president has asked him that how can you do this early morning at 7:30? What was the urgency of doing this? Okay, so one who preaches gospel, okay, should also follow that gospel, right? So it is something, it is in English that see who is preaching the gospel. So devil should not preach the gospel. That is what the whole thing is. That if you are talking about constitutional morality, it is something that for you also to follow it, right? If you are not following it, then in that case, as I told earlier, it only happens to be something called as a very fashionable way of invoking Dr. Ambedkar and speaking something without getting into the gist and sense of it. When said Dr. Ambedkar would have been alive today, he would have completely been very critical about the way in which this government is functioning in undemocratic manner, right? So you can't have the functioning of the government in such an undemocratic manner just because we have the power in your hand. The power has to be used in the wise sense. So he says that there's one thing you have a legal right. The other thing is that is it wise to do so? Okay. So this whole question would be that is it wise to do this? And that is what constitutional morality comes in picture. They say that no, this is not correct to do so. The problem, Priyadarshi, here is that how do majority Indians actually define morality? Today early morning I was reading Dr. Ambedkar, A Philosophy of Hinduism, and I would quote him for the benefit of your audience. And he says that Hinduism is a gospel of Superman, and it teaches that what is right for the Superman is the only thing which is called morally right and morally good. So it means that it is a gospel of Superman. It teaches what is right for Superman is only thing which is morally right and morally good. And therefore, what is morality, what is public morality is something what the Superman here would be, upper caste Superman here would be, what the religious head would be, something which is right here then is moral right for everyone. And in this context, Dr. Ambedkar is proposing that no, morality should be based on equality, fraternity, and liberty. Okay, so his context is completely different, and that is the basis on which he has based your constitution. Okay, the point is whether the people are holding constitutional post, if they say that they stand by the constitution, what is the set of morality they are standing with? Is there a set of morality which comes from the morality of Superman? That is what you're projecting every day on the national Doordarshan television, or morality which flows from the Constitution of India, which is based on liberty, equality, and fraternity. Okay, so you will, to answer your question, that you will see the people in power, they speak one thing and they do one thing. So they are not basically upholding the constitutional values.
Right. Sir, another you quoted Dr. Ambedkar. Baba Sahib spoke very with insight and eloquence in the Constitution Assembly debates about constitutional morality. He also quoted the classicist George Grote. Sir, in this context, and you also talked now cited the example how the people in power preach one thing and behave and practice something very different. So in this context, sir, what was Baba Sahib concern regarding the elements of constitutional morality, not only from the person who are holding a constitutional post, but in general, from
Uh,
lawyers, from public intellectuals, from academicians.
right. Uh, he was very concerned about a set of morality to be followed by everyone in public life. So in his political party, his people who are associated with him, he was more concerned about in public life, you should have a very transparent life and a set of morality to be followed. But let us understand that for us, morality would be a person who's unmarried for all of his life. A morality would be a person who's vegetarian. Morality would be a person who doesn't speak lie, a person who has experiments with truth and all those parts. But beyond that, morality is also about the values, the philosophical values to which you are associated with. And Dr. Ambedkar has time and again said that the values on which I am associated with is liberty, equality, and fraternity. And he tried to imbibe it in his all of his discourses and his personal life. So interestingly, if you see that when he was giving an interview to BBC, he said that I have taken liberty, equality, and fraternity from the philosophy of Buddha. When he's writing the same in Annihilation of Caste, he says that a religion is a true religion only when it adheres to equality, fraternity, and liberty. So what is constitutional morality for Dr. Ambedkar? What he speaks about, that every individual, maybe people in power, people holding up positions, and people who are not holding positions, people who are in social life, should adhere to this principle of liberty, equality, and fraternity. That is what he's talking about. And in general, if you want to say that, what do you mean by constitutional morality? So it would emphasize on certain principles. And if I want to quote them, if I want to just list down those people or elements, would be certain elements of self-restraint. You can't just speak about whatever I say is right. See, when he said that Satyagraha is an grammar of anarchy, that is what he's meaning about. In 2012, there were a huge crowd gathered in Jantar Mantar, and they said that Parliament doesn't have sense. What we decide is the law. So it was completely, you can understand how it is a grammar of anarchy. So constitutional morality should have a sense of self-restraint, respect for plurality. You should always respect that there could be a different opinion. Okay. And that is what democracy would be. That is what Bangesh, you spoke about. What do you mean by democracy as a way of life? You should have respect for plurality, that there could be different views and there cannot be only one way. Okay. Differences of process. There could be different ways of doing it. It is not, this is the only way we should do this. Skepticism about authoritarianism. So if somebody says that I'm the whole Superman who will change everything, you should be skeptic about it. That is what Dr. Ambedkar is all about. He says that never put your liberty at the feet of anyone who is too superior. At that time, he has a context of Nehru, and at the time, he has a context of Gandhi. Now we have different contexts, but his statement is saying that you should be skeptic about any authoritative claims. And you should also be skeptic about any popular sovereignty claim. We have the mandate of the people is something very problematic. Mandate of the people may not always be right. That is what the Athenian democracy was about, that we people will decide, and people decided that Socrates should die. But it was not always right? So we should be skeptic about the claim of popular sovereignty, and we should have the concern of open culture of criticism. This is something which Dr. Ambedkar has always been standing for. He says that there should be a culture of criticism, right? He said that I would be the first one to protect my critic. So if you ask me, what do you mean by constitutional morality? I'll say that if you abide by these principles, means what do you mean by liberty, equality, fraternity? If you abide by these principles in your life, this is something which we mean by constitutional morality. This is what a society could be about. Yeah.
Sir, while presenting the case on constitutional morality, you cited some of the judgments by the Supreme Court, particularly in the case of Naj Foundation. Yes, in a couple of years back, we have seen good judgments in case of Sabrimala, Naj Foundations, but there were also some of the judgments where Supreme Court has not applied the doctrine the way they wanted to. Uh, I mean, you can take the example of SC/ST Prevention of Atrocities Act, the way they have gone and sort of citing the reason of misuse of the act. Also, the reservation in promotion case of reservation in promotion. Also the case of Judge Loya's death, the petition of Judge Loya's death. So how you see, the question is same. The constitutional post, person who was holding the constitutional post is asking to apply constitutional morality, but who is not doing. On the same hand, the institutions in a democratic institutions is also doing. Is Supreme Court excluding something, or is Supreme Court selective when they want to apply the constitutional morality?
Yeah. When we say Supreme Court, we should be very clear that though we have one Supreme Court mentioned, there are basically 27 Supreme Courts, because the number of division benches who sit, right, they decide what the law is. So it all depends upon who is presiding over and who is deciding the case. All those examples what he gave were, at least to the extent they spoke about one interpretation prevail over another interpretation. And in that case, I would not bring in constitutional morality discourse. But my major concern would be that how come Supreme Court registry has basically allowed a person to file to the matter to be brought before the Supreme Court within 8 hours. Arnab Goswami has filed a petition at 8:30 in the evening, and morning 10 o'clock it was therefore hearing. How does this happen? So when we talk about equality before law, are there someone more equal than others? So here in the question of constitutional morality would definitely come in that you are very arbitrary in nature. Or you can take the case of Ranjan Gogoi, when there was an allegation made against this person regarding sexual harassment by a woman. At that time, this person, he considered a bench and he sat in the whole proceedings. Now, forget about constitutional morality. Principle of natural justice says that a person cannot be a judge in his own cause. And interestingly, the Supreme Court has said that he is not guilty for it. And also the Supreme Court has reinstituted that woman, saying that she was also not at fault. So if she is not at fault and he is not guilty, so what the matter was about? So the point is about constitutional morality would come in the administrative governance of the Supreme Court. The constitutional morality issue would also come in once the court are relying upon closed envelope doctrine. So the government comes up with a very closed envelope, only the judges read at it, and then they say that we have decided in one way. No one knows what has happened, what is there in the closed envelope. Now, this is the point wherein we speak that what is the constitutional morality you are talking about, right? You should be transparent. We are open courts. And how long and how far this closed envelope are going to continue? And you can see that whenever this closed envelope issues came up, these were the issues wherein the government was in trouble. The government was in problem. The court basically is anti-majoritarian. It should always question the government whether you're right. You're made constitutional, ask you to question the government. That is what the separation.
I think sir's internet connection is down. Sir?
Let's wait for a minute whether he's back again. Yeah, he's back. Unmute him.
Are you back?
Yes, he's back. Unmute him.
Yes. Sir?
Fine.
Yes.
So I suppose, Priyadarshi, the issue is not about that the court should have decided in favor of scheduled caste or should have not decided in favor of scheduled caste. This would always be a matter of what type of interpretation would prevail. The more issue would be that how the Supreme Court judges are functioning in the recent past, right? And Justice Gogoi's whole conduct, his decisions, publicly he made a statement against NRC when he was holding a position and then getting a position in Rajya Sabha, is something wherein the discourse of constitutional morality would be brought in. And in case of scheduled caste, scheduled tribes and all other parts, I suppose, that the discourse of constitutional morality could be brought in, that you don't look at the values on which these laws have been made for. So why we need a 100% reservation in a scheduled tribe area? For the reason that nobody goes there to teach. And therefore, you can't be always be mathematical in nature. Life is not mathematical about 50%, 100%. Life is something more than that. And therein, you should have been interpreting this provision in a completely different context. It should have been worked out to be an exceptional clause. and not as a rule, because it was not a general rule to make 100% reservation. It was only in the tribal area the tribals would get reservation. Because of the rise of nationalism, there were no other teachers who were going to teach them. Okay, so without reading the context, if he gives judgments, then in that case you're basically not following the norms of interpretation, I would say. Right.
Right. Sir, the point you make is very valid, no doubt about it. But sir, again, the same quote, as you cited, particularly the case of Bhima Korega, where the close envelope, fashion of close envelope is being taken into consideration, which is not open to the lawyers, which are not open to the witnesses, and which is not open, which is not following the principles of transparency and so on. So I think the point you make is very valid, that how the judges are interpreting and how judges are functioning in the apex court is certainly a question. Therefore, sir, one more point which comes from your presentation is that we have to interpret constitutional morality in the framework of liberty, equality, and fraternity. But sir, the
Sorry, I
point
didn't
is,
got your point, last point.
uh, you said that constitutional morality has to be interpreted in the framework of liberty, equality, and fraternity, right? Now, it's very true that the organs which are functioning within the Constitution of India will aspire to interpret in that way. But my point is, sir, when the majority of the society are following their own rules of caste and not rule of law, in that case, how constitutional morality will prevail in the society? Or whether the academicians produced by such society, lawyers produced by such society, or the people are being appointed as a judge from this society will interpret constitutional morality from those trinity of liberty, equality, and fraternity.
Uh, that was the concern for Dr. Ambedkar when he was drafting the constitution, because that is what says that Indian society is inherently undemocratic. So we don't have these values at all, and that's what he cherished whole of his life. But he also saw to it that now the constitution should be interpreted on the touchstone of constitution per se, not on the touchstone of your social values. You are right when we said that caste is a law, right? So caste itself is a law. It determines your behavior. And that is what Dr. Ambedkar also spoke about when he spoke about waiting for visa, and he spoke about his memory, that how he was made to sit in a school with a different goni and other part. And he said caste is the law, because that is what the law is about. And nothing has changed in last 70 years again. We still see caste as a law which is governing. People are not allowed to enter the temple and all the part. But here in this case, the constitution is there. We were much aware that Indian society is not egalitarian, but the task of the constitution is to make Indian society egalitarian, right? And therefore, people who are holding the constitution has the duty to enforce the constitution. Unfortunately, people who are holding the constitution are there for the reason to govern the people and not to enforce the constitution. So they don't feel that liberty, equality, fraternity should be enforced. They always feel that we are here to govern. So Raj Tilak ki karo tayari, ये जो सब बातें आती है, they are very feudal in nature, but they come in a very democratic structure in India. So this dichotomy, how do we solve it? It could be solved by social movements, and you don't have a ready-made legal answer for this. You can say that you make such type of law and people will stop it. The more Ambedkarite movement, the social movement, the reformative movements become stronger and stronger. It gets its roots stronger now. Society would change. Unfortunately, now the right-wing movement has become stronger, and therefore the society is such that people would feel that even if we dictate religious norms to people, still it is justified. And the court judges also would feel that I am bound to my religion more and less to the constitution. So in that case, social movements is the answer to this. You can't leave everything on the constitution to function and do nothing. So entire caste movement has to be more stronger on ground.
Sir, are you up for a few more questions, sir?
Yeah,
We have to,
2, 3,
okay.
whatever it is.
Sir, as we were discussing about the constitutional morality and the power, uh, the, the, the Supreme Court, for example, being the custodian of the Constitution, the guardian of the Constitution. And we see now a contradiction between what is going on, and there is a question from the audiences as to the collegium system, the method of selecting the judges. How does it accords with the discussion that we are having here about the constitution, constitutional morality, and the Supreme Court being the custodian of the constitution, the guardian of the constitution? How do we resolve these contradictions, sir?
The framers of the constitution are very clear that the judges of the Supreme Court, when they have been appointed, the executive will have a say into it. And that is what they say, that the executives are basically been the people who have been elected from the society, from the parliament, and therefore they're answerable to the people also. That was the basic scheme we have. Later on, when the judges said that the executives are determining making political appointments, they took up this whole part and said that we'll have a collegium and we'll appoint ourselves. Nowhere in the world the judges appoint their nominees and they appoint themselves. Now, has the collegium system been successful in its functioning? The answer is not that, because we had all great judgments even before coming of the collegium, and we have all such type of weird judgments even after coming of the collegium. Right now, the Supreme Court, which has earlier said that we have to relook at the reservation system, and now who are the beneficiaries of the reservation should be excluded, and those who are not beneficial should be brought into the mainstream. When Supreme Court said few days back, the same also applies to them. They should also look at it that we should not have all mishras and all upper caste and upper class people or people of the same chambers coming up to the judiciary. If that is the case, we don't have 3 or 4 generations. There's no country which have such of 3 or 4 generation judges coming up in the judiciary one after another. We have to make this institution more open to all the sectors, because see, one of the justification of reservation we always said is that we should have a participation in the decision making of the country. So do we have a participation of all the sections of the society in the decision making? We're not talking about how many Dalits are there and how many Adivasis are there. The point is that whether the judiciary is dominated by one class, one caste, or one chambers. If that is the case, then in that case, does it not make the judiciary undemocratic in nature? So the point is that whatever manner you make an appointment of judges, you will have problem with the judges, right? So you have a collegium system, you have people like Arun Mishra coming up, and you have people like others who coming up who says that we should stand with the government in power. So in the collegium system, people say that we have to stand with the government in power. It is in the national interest. And even when we never had a collegium system, we have people who were in praise of Mrs. Indira Gandhi. So whatever happened, the people who are there in judiciary, they are going to side by the government for certain reasons. Okay, so a collegium system is very much undemocratic in nature, which goes against the basic framework the framers of the constitution has brought into. The basic framework was that the executive will have an important say in appointment, which they have completely removed. So in my opinion, if you ask me, it is quite undemocratic. It needs to be changed, and it should be more participatory in nature, and it should be more open in nature.
Nitish sir, you have any question left?
No, I mean, so far there are no questions from the audiences. So thank you, sir, for taking those questions. It was wonderful discussing those questions with you. And but certainly there are some issues which come up from this discussion. And we would like you for another discussions like representation in judiciary, sort of rule of caste and rule of law, and some of the points which particularly Babasaheb made, citing the quote which you quoted, that democracy in India is only a top dressing on Indian soil. So in that respect, whether our democracy is in the form of democracy which framers of the constitution envisage, or it's going into popular democratic form, populist form, which are some of the points which has emerged. We'll certainly have some discussions, certainly have some sort of deliberations on debate on this in a later part. Thank you, sir.
Before we conclude today, we formally thank Dr. Nitish Nawsagare for his very erudite and wonderful insights into what is the constitutional morality and the contemporary issues that we face today, the challenges to the constitution itself that we face today, and which are the possible ways to go forward. He has very succinctly mentioned and implied whether the culture can be legislated, whether the religion can be legislated. And I think that's a very big question, whether the culture or the religion can be legislated. And we know that Baba Sahib Ambedkar tried to find his answers for this deeper changes in the society. And therefore, the questions like these are very important for us to ponder. And therefore, the dear audiences, before I thank Dr. Nitish Nawsagare and Priyadarshi sir for having raised these very important issues and the questions. Thank you, audiences. And at 2 o'clock, stay tuned. We are going to look at Buddhism as a way towards total revolution or total transformation by Gigi Rajavardhanan from Tamil Nadu, and we will be live on at 2 o'clock. Thank you, sir. Thank you,
Thank you,
Priyadarshi.
Mangesh. Thank you,
Thank you,
Priyadarshi.
thank you.
Thank you, Karwan. Thank you so much.